Well, good afternoon and welcome to today's Business Success Series presented by Manulife. Your legal questions answered. My name is Ian McLean. I'm the President and CEO of the Greater Kitchener-Waterloo Chamber of Commerce. Before we get started, I would like to take a moment to acknowledge that we do live and work on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples, as we seek a renewed relationship based on a foundation of mutual understanding and respect. As participants in today's virtual event, we are coming together as one. We believe everyone is free to be their true self and receive the same respect and opportunity, regardless of age, ethnicity, gender, culture, identity, sexual orientation, beliefs, or language. We hope you will help join us in fostering a positive environment here today that is a safe and welcoming space for all. We know that there is more that we can do, and we are committed to listening, learning, and growing as we go. Today's session would not be possible without the continued support of our sponsors. And so a special thank you today to our title sponsor for the Business Success Series, Manulife, our platinum sponsor for the series, the Immigration Partnership of Waterloo Region, and to June's sponsor, Learners. These organizations and many others are committed to supporting our local economy and providing businesses with the resources and tools they need to thrive. Just before the session begins, I'd like to go over a few quick reminders. Please ensure your microphone is muted throughout the presentation so we can reduce any background noise. If you have a tech-related question, please comment in the chat section, and a representative of our team will get back to you right away. If you have a question for today's speaker, I'll try and gather those throughout the session, and the speakers will do their best to answer as many as possible. All those can go in the chat function. All attendees will be sent a recording of today's presentation, and it will also be made available on the Greater KW Chamber website. I'd now like to invite Mark McCauley, Associate Lawyer at Learners LLP, to introduce today's guests. Mark.
Thank you, Ian. Learners is proud to be this month's presenting sponsor of the Business Success Series. As part of this series, I have the privilege of introducing today's guests, Alicia Christian and George Hamzo. Alicia Christian is a corporate lawyer and Learner's Chief Privacy Officer. Alicia's privacy practice focuses on advising businesses and other organizations across Ontario on privacy issues, including preparing privacy policies, developing training programs, conducting privacy impact assessments, and managing privacy breaches. Alicia is certified by the IAPP as a Certified Information Privacy Professional in Canada. George Hamzo practices exclusively in the area of labor and employment law. George has expertise in virtually every employment-related issue which may arise in the workplace, including human rights issues, workplace investigations, employment standards legislation, employment contracts, and restrictive covenants, including non-competition and non-solicitation agreements. His work involves both advisory and advocacy services, where he represents both employees and employers. Thank you for joining us today. I will now pass it back to Ian.
Well, thank you, Mark, and I'm glad that at least someone got the memo that it was Red Day today. Alicia and George apparently missed that memo, but that's okay because they're the exciting part of this session today. But thank you, Mark, for that introduction, and thank you to Learners for their support of this very important program that we run, Business Success Series, every Wednesday, and Manulife and folks like Learners give us the opportunity to get information that all of our members, especially small and medium-sized business, will need and won't necessarily have the expertise for. So thank you for that. Listen, let's dive right in, and I know we've got some questions set here, but maybe Alicia and George, let's start with maybe just your observations, because what we have seen over the last, and there's pre-pandemic and then there's pandemic and we're post-pandemic, and we'll get to the back to normal or back to what resembles normal. But I'm always interested because everyone experienced COVID differently over the last 2 years. So either some personal observations and or some observations of how your clients got through the last two, or navigated the last 2 years. So I'll start. Alicia, why don't you take a crack at that?
Sure. So I think one of the things that I noticed the most in terms of my clients is that a lot of them were forced to move to online platforms when they didn't necessarily have those before the pandemic. A lot of small businesses had to pivot unexpectedly. And a lot of them don't have, tech people on staff to help them do that. So there's a lot of learning by trial and error. Obviously, I was getting involved in helping them to make sure that they're complying with privacy legislation because any kind of online platform or online business collects a lot of personal information, and just counseling them to make sure that they were doing it in a way that complied with privacy legislation. From a personal aspect, I'd say I didn't realize how much I liked working in the office until I no longer could do it. Certainly at the beginning of the pandemic, I was quite excited to kind of have a break from the office and work from home. That slowly wore off, and we've now moved into a hybrid type of setup where you're encouraged to come in if you're comfortable doing so. And I certainly do think that that's something that we're going to be seeing across industries as the new norm, especially if businesses want to keep talent.
Well, two comments. One is because your office is right beside ours, I believe. I'm being side by each. So,
Yeah.
Aaron Street is a pretty beautiful street to be on, and it's a nice part of the world for sure. And the other is that I guess we all just on a personal level, we all would have missed the routine that we get into. So, but I do think the last point, and then I'll move on to George, is the new normal will involve hybrid working for those that can. It's almost I think employees will have an expectation that there'll be at least some of that, that there'll be some opportunity to work at home, where I'm not sure before the pandemic that was on many people's radar screen. So it's going to be interesting to see how that balances out. George, what about you and personally and your clients?
Yeah, I mean, I'd echo a lot of what Alicia's saying there. There's been a lot of sort of learning on the fly for a lot of my clients. From an employee perspective, I agree with you, Ian. I think there's growing expectation that this is the new norm, and sometimes my employer clients don't share that expectation, and so it's sort of a butting of heads. And obviously they want to keep talent. They want to make sure that they're attracting good people who are there to work for them. But it's sort of a balancing of interests. So that's sort of how I would describe things, just in terms of, what an employer is willing to live with, just in terms of that balancing of interests. So, I don't think we're out of this yet, in the sense of, I don't think we've sort of landed at a final spot for a lot of businesses, at least in my own practice. I still think, changes are coming, or my employer clients will be forced to kind of look harder at those solutions that some other businesses have implemented. Personally, it's been an interesting 2 years. I've had a young child coming to the world at the beginning of this thing, the original COVID baby, I like to call her. And it's been interesting, seeing that side of it, because, obviously a lot of my practice are, sort of family responsibility issues, and that being covered by, potentially the Human Rights Code. And there's, so I've sort of seen that other side of it. So it's been interesting. I, like Alicia, I didn't realize how much I liked coming in until I was told I could not. So especially when the children are sent home at certain periods of time. So I'm anxious to get back to normal. But as you say, Ian, I think we're a long ways out from that.
Yeah, I must admit, I was lucky to have my kids are a little older. So when they worked or went remote, all I noticed is that about 12:30 they woke up to get something from the fridge, and it's the only way I would have known they were in the house. So not quite the same circumstance, but remote learning, etc. the one thing I would say, and the reason I wanted to ask about this is, COVID hasn't gone anywhere. It's still out here. And I think part of, as Alicia, you mentioned, is the remote working and making sure you're set up is very good. That's a good insurance policy on there being another outbreak in October, November, or December, where it may make sense for those that can to work at home. So having your, electronics and your equipment and your Wi-Fi and your protected material, both for your clients, but also personal material, it's just wise if you're going to have people working at home at all, even part-time, or leave yourself the opportunity that you can stay open by allowing your staff to work at home if and when there's an outbreak, or, frankly, for that matter, of just a normal flu outbreak. It probably makes sense so you don't get your staff sick. So that's just important context for the conversation today. Let's start. I think in general, many things came into focus, even for us. No one contemplated a worldwide global pandemic when they were doing offer letters or employment contracts. I suspect it wasn't in just about anybody's, but let's talk about employment contracts. What's the importance of having one, especially, and I think this is we don't have to keep referencing COVID, but moving forward, I think we've brought into focus some of the reasons why consulting with your experts, whether it's your accountant on finance or your lawyer on these types of matters, is really important. So what's the importance of having an employment contract that allows the employer to have certainty around around their business operations?
Yeah, it's a great question. And I think, Ian, you're correct. I think COVID brought this into focus, sharp focus for a lot of people. When this initially started, and I think last time we spoke, Ian, maybe a year ago or so, I had mentioned this, but it's worth reiterating. A lot of employers moved to lay off their employees, right?
Mm-hmm.
They, just to have some cost savings because, they didn't know what the future held. A lot of my clients were surprised to learn that they just didn't have a standing right to lay off an employee if they needed to. That is something that is, required by the terms of employment. So what I mean by that is, while the Employment Standards Act sort of, provides rules about, how long a layoff can last, what needs to happen during that period, it doesn't automatically apply to an employer. So at the beginning of this thing, I had to, have these tough conversations to say, well, if you choose to lay a person off, it may be construed as a constructive dismissal. So I think what I've done is, since this began, it sort of hammered home for me that, layoff provisions should be in every employment agreement going forward, unless you're certain that you're not going to need it in the future. And that wouldn't have been something I would have said previously, right? There's a lot of professions, a lot of jobs that don't require an employer to lay off an employee. But I think what COVID has done is just sort of brought into sharp focus that, again, you don't have that standing right, that if you're going to do that sort of thing in the future, you need to have something in your employment agreement or some sort of amended agreement, something written down that the employee agrees to sort of establish that right for you. One thing sorry, go ahead.
Go ahead. No, go ahead.
Yeah. So one thing I think that's going to come up is that the audience may have heard of what's called the infectious disease emergency leave. And basically that is a protected leave of absence for an employee, but it also allows the employer to basically not provide any work or wages to an employee under certain circumstances because of COVID-related reasons. That is set to end, I believe, on July 30th of this year. Now, in fairness, the government has extended it throughout this 2-year period, so they may choose to extend it again. But I guess, at the risk of being radioed on this thing. I expect it to end on July 30th. I think given the way things are going with the lifting of restrictions and that sort of thing, I think it probably will end. So if for my clients who have employees who are still on an infectious disease emergency leave, there's not a whole lot anymore. I think during that 2-year period that they've sort of come to terms with it. But for those who are still on, they're going to need to make a decision at that point, either lay them off, right, pursuant to the regular rules that existed prior to COVID, or try to structure some kind of separation agreement or severance package for that person. So and if you don't have that right in your employment agreement with that employee, then that's something that maybe you should look at in the next few weeks or so to make sure you're able to do that.
It brings up the point that I know when we looked into it and the first year we were all hoping there would be a vaccine, and then we discovered there were vaccines, and what requirement might there be to take them, and unless the government mandated that you needed them to get into certain places, and that there's still, roughly speaking, probably 1 in 5 Ontarians for one reason or other, either they're too young or have just haven't got it, that do not have a vaccination. But I'm fairly certain, unless you're in healthcare professions, that might have said you might have to take some form of immunizations, nurses and doctors and others that are in a hospital setting. Is that the sort of thing that as we go through and look at employment contracts is to try and imagine things that might happen? And I'm the first one to admit I didn't imagine. I know we've been through SARS and we've been through various things, but it never had the impact, not even close, that COVID has had in shutting everything down. So hard to imagine a scenario that happened. But are these the sorts of things that you should be looking and contemplating so that you have some provisions in your own employment contract? One of the challenges that you reference is a lot of folks had to rely on the government saying, okay, well, these are extraordinary circumstances. Otherwise, they would have forced a lot of businesses out of business because they couldn't afford to pay them and they couldn't afford to buy them out, if you will. And so they needed to lay them off without cost and use the mechanisms, the public finance methods of getting cash flow support for them. Otherwise, businesses would have just closed down early, and that's what was trying to be avoided. Are those the sorts of things that you should be trying to think and modernizing, if you will, or reimagining your employment contracts?
Yeah, I think that's a great point, Ian. And like something to remember about all this is that the employment relationship is essentially contractual, right? So it relies on the party setting expectations from the beginning as to what is permitted, what's not permitted. Now, of course, this is a heavily regulated industry. There are certain rules you cannot violate, that sort of thing. But so long as you're working within those, as long as you know what they are, and you're working within those parameters, there are things you can do. So to take your example there, Ian, I mean, I have been over the past year or so been advising some of my clients, consider putting an actual provision in there related to a COVID vaccination, if that's something that you want to consider, right? Now, of course, it's got to be drafted in a certain way so as not to run afoul of things like the Human Rights Code. Okay, so there's no absolute right to get somebody vaccinated if, for example, they have a legitimate medical reason for not doing so. But so long as you're working within certain parameters, you can impose those types of rules, restrictions, if you like, at the beginning of employment. And I would say it's much easier to do it at the beginning rather than midstream. You try to change the terms of employment to essentially require someone to get a vaccination, right? So again, I think that just highlights the importance of thinking it out beforehand and making sure that you have everything in there that you want.
Yeah, and I guess that's you personally you can't force someone to get a vaccination, but you need to have the the requirement in there, because that changes the how does the exit and who pays what if it's not in a contract. And that's why, as you say, good fences make good neighbors when it comes to employment contracts. Listen, Alicia, one of the things that came up, and I know one of the questions that I had was around electronic newsletters, et cetera, that came out of COVID. But I've noticed in the era of we can't go out and do anything in person for that period of time, it seemed to me that my phone was ringing a lot more with those unwanted, hi, it's John or Betty or whomever. Would you like can we sell you something over the phone? And even more, the emails, the electronic emails, the unwanted, basically junk emails.
Yes.
So maybe I want to touch on that first, and then go into the requirements that you should have, but aren't there. Was that something that was that type of unwanted calls and emails and communication? Was that something that sort of flared up during COVID?
I think there was certainly an increase in terms of the number of electronic communication that businesses were putting out, because it was really one of the few touch points some businesses might have had with their customers, especially if their brick and mortar stores were closed. So I definitely saw an increase in terms of newsletters, things like that. The legislation that sets out the rules for sending electronic commercial messages, it was brought in well before COVID, probably about, I'd guess about 8 years before.
Yeah.
So we have had legislation, it's called the Canadian anti-spam legislation. So it did exist before, but certainly there was an increase in my perception as well to how much we saw in our inbox. And I think just out of necessity for some businesses to maintain contact with their customers.
Yeah, so that Canadian anti-spam castle, I think it's called,
that's right.
It's there, but it's legislation's only as good as the enforcement that goes along with it. And it seemed that lots of other fish to fry during COVID. But let's talk about, we're back at this. It is one of the tools that business use, which is, whether it's social media or email or some electronic version, electronic newsletters to customers and potential customers. So you don't have approval to send it to them, but you're gonna somehow get in touch with them. What do you need to do to comply with privacy laws? Because my guess is that's something that people will get a little bit more ornery about, is getting bombarded with online, unwanted online and social or emails in particular.
Yeah, and the thing to keep in mind too, if you are thinking about having a newsletter, I mean, it is a good way to keep yourself top of mind to your customers, but at the same time, you don't want to do it in a way that offends them. So like a daily type of interaction would be something where you're likely going to get take me off your list right away. In terms of actual compliance with the legislation, you need to have their consent. So it's not like you just get to go willy-nilly through the internet, and it's called address harvesting. You don't get to just, find a whole bunch of people that you think, hey, I want to, get this person on my newsletter. You can't do that. You have to have a person's consent to use their email address, collect and use their email address for marketing purposes. And that's really why you often see when you're making an online purchase, you fill out all the information, your address, your credit card, and then there's often a little tick box at the end saying, I consent to receiving communications about sales, promotions, etc. And the reason they have that little tick box there is for CASL. So they can point to that and say, we have this person's consent to send our electronic communications to them. Now, there are a couple of circumstances where you can imply that you have a person's consent to send them electronic communication. So if you've had a business relationship with the recipient of your newsletter in the past 2 years, then you can imply that you have their permission to send your newsletter or electronic mail And so that would be they've purchased something from you in the past 2 years, or they've contacted you and there's been a bit of inquiry about the services that you provide, then you can, in that case, imply that you have their consent. And likewise, if an organization has a non-business relationship with the recipient in the last 2 years, and that really would be something like a nonprofit organization who's sending a communication to a former donor. So you can, there are a couple of instances where you can rely on implied consent, but just, obviously overly cautious lawyer, I'd be like, you want to have something documented that you can point to if there ever were an issue and you get a CRTC investigator knocking on your door saying you've failed to comply with CASL. And the other thing to keep in mind, if you do use an electronic newsletter to communicate with your clients, you have to have an unsubscribe function in every single newsletter. So it's not good enough for them to just hit reply. It needs to actually say unsubscribe. And so you need to make sure that you're giving them an easy ability to withdraw their consent to receiving your communications.
Yeah, that can be a savior for those companies that decide they're going to do daily or bi-daily notes. It is important, but one thing and I think you can, maybe just comment on this. The responsibility for CASL is not something you say, well, that was my, outsourced communications company. This is responsibility of, in our case at the chamber, ultimately the CEO and the board are the ones responsible for making sure we're complying with that. I mean, I guess that would be the same with anything else, but it's not something you can say is someone else's responsibility. And there could be costs and certainly aggravation of having to explain if you're not doing that. I mean, so I think it is important that senior executives and boards understand, even for a not-for-profit, they have specific responsibilities.
For sure. And I mean, you're right, you hit it right. You can't just use an excuse. Well, I hired a third party to look after my email communications for marketing. That's not good enough. You're still responsible. And there are potentially very significant fines that a business can receive under CASL if they don't comply. There need to be quite egregious breaches, but there's been some that have been like 500,000 plus because of how egregious the breach was. So it's not one of those things that you just get to be like, oh, whatever, it's not a big deal. In the right circumstance, it is. Yeah.
Oopsie is not a defense, right?
No,
Oopsie. No, yeah, the oopsie doesn't work. Okay. No. Now there's one question that came in, and I'm not sure whether this is a George or Alicia thing, so I'll let you guys arm wrestle over this one. But good point. With working at home and many labor agreements and the communication function too of staying connected with the employees, the question came in around, do we need to refresh employee contracts to reflect the health and safety requirements that you would still have, even if you're allowing someone to work at home? You presumably still have, because the hours that they're at home but working for you are work hours, and you have a responsibility for their health and safety. So whether it's
I think I can jump in.
Okay, so George, ergonomic desks and
right.
Appropriate screens, like all the safety things that we would normally have in an office, that responsibility is assumed translates or transfers to the home office setting.
Yeah, I actually think this is settled even before COVID. I think, for employees that work from home, for whatever reason prior to this, it was considered a workplace, right? Under the Occupational Health and Safety Act. Now, that being said, is it a good idea to sort of alert the employee to that issue that, it is a workplace, it needs to be up to a certain standard, that sort of thing? Yeah, I think it's a prudent idea, and I think it probably makes sense to do that. Certainly, if you're concerned about it.
Well, I know in some circumstances, some of my staff early on working in a small apartment, their choice of desk station would be the island in their sort of kitchen / eating area their bed or their couch. Like they didn't have a desk. They couldn't
Right.
fit a desk, even if you wanted to fit a desk. But you're still responsible for saying, how can we accommodate, as an example, making sure you have something that's appropriate for look, working at home for 22 months and staring at a TV screen. I've developed a bit of a bad back. Now, a lot of that's on Mike, because we've all been allowed to have stand-up desks and encouraged to do those things. I may not have chosen to do that all the time, but I think that's important. Even though, to your point, it would have been a requirement. Not many people, so many more people would have been working at home, and I think employers just need probably a good decision to either refresh that employment contract or remind employees that of their responsibility, and so that they may have to come and look at what's required if they're going to be working at home.
Yeah, just to piggyback on that, Ian, especially if, I think there's a distinction to be made if employees have a sort of a recognizable disability of some kind, right? If they have, I don't know, sciatic issues or whatever it is.
Yep.
I'm still fairly young, I like to think, but my back is not what it used to be. And so, those are types of things that, if it, really it doesn't take much to establish that an employee has a disability, really. I mean, we're talking a doctor's note that sort of attests to that. And then once that happens, there we're talking about the duty to accommodate. And then, you sort of have to engage with the employee on those issues. There's no sort of automatic entitlement, right, Ian? I mean, it really does depend on the situation. Just because an employee says, I want, they send you a link to I've had this happen to one of my clients, they send a link to a, $1,500 chair, and they say, I need this, and, only this, and this is the only thing that's going to work. Well, that's probably not going to fly. I mean, the accommodation process requires both the employer and the employee working together to come up with a reasonable solution.
So that's a good point. I mean, for those that might have a disability, and it could be anything from eyesight. Like, I know, although I'm staring at the box that's on the floor beside me, that's got a 45-inch screen, because I'm basically blind and I can hardly see either one of you, and I got a big screen. I know I need a bigger screen just because of my eyesight. I mean, that would be the sort of accommodation of saying, hey, look, if you're going to be working at home, you're going to need some of those types of requirements. How far does an employer need to go? Like, I mean, are there sort of, you've mentioned that, sounds to me like it's one limit, because you need a good chair doesn't mean you need the $1,500 version of a good chair. You need something that fits certain parameters. But are there limits, or are there sort of yard posts?
Yeah, certainly. I mean, there's no bright line test, and this is kind of the tough thing when I'm sort of advising my clients on the issue. They'll be presented, usually this is how it goes. The employee, maybe confronts them, or, basically tells them, here's what I need. I have this medical issue or whatever it is, and I need X, Y, and Z. Well, I think the first thing I would say to that employer is, well, who are we hearing this from? You do have a duty to accommodate a disability, but there's also obligations on the employee as well to engage in that process. So what could that mean? Well, usually the employer is operating from sort of information deficiency, right? I mean, they don't really have all the information that they need in order to make a reasonable determination as to, what are this person's impairments? How does that conflict with their duties, right? The essential duties of their position, and what practical solutions can the employer sort of implement to help that person, right? So one thing that I often am recommending employers to do with sort of guidance of a lawyer to make sure you're doing it correctly, but is essentially, requesting further information from that person's healthcare practitioner. You're entitled to do that. Again, subject to certain parameters, you are entitled to do that. You're entitled to, first of all, make sure that the request is bona fide, right? Especially if, this person has been making requests in the past and, you have reason to believe that they're not legitimate, right? You're also entitled to know what the prognosis is, not the diagnosis. If there's one thing I would say about requesting information, you're entitled to a prognosis, not a diagnosis, right? So you're not entitled to know what specific, mental health diagnosis that person has, if that's the issue. But a good way to think about it, Ian, is you're entitled to that information that you need in order to accommodate that person, right? Because that is your obligation, right? And so that would include things like impairments. And so once you gather that information, then I think you're in a better position to sort of assess those things. Now, let's say, for the sake of argument, that that person does have a disability and their doctor perhaps is supporting a particular accommodation plan, and you don't want an employer is questioning as to whether or not they have an obligation to provide it. I think at that point, that's where we start to talk about what's called undue hardship. Okay, and basically the idea there, if I can vastly simplify this very complex area of law, is the idea that there's going to be, the cost, right, of accommodating somebody is too much, right? It's unreasonable to expect the employer to do that. Okay, so that could play out in a number of ways. The two most common ways are it costs too much money, right? If I implemented X, Y, and Z, it would cost us too much money. That's really difficult to establish. It's sort of clear at this point that the cost has to be substantial, not trivial. And that is really dependent on the circumstances. You can imagine, for example, Costco can incur a whole lot of costs, to accommodate a specific employee, whereas, the person running the sushi shop down on the corner, right, they're not going to have as much sort of funds to be able to accommodate somebody. And then the other issue that you might look at are health and safety implications, right? So the sort of classic example here is, there's an employee who needs to take medicinal cannabis, for example, right? But they have a job that requires them to be up on a skyscraper cleaning windows, right? Well, the sort of health and safety implications of allowing that person to do that job at that point in time are probably outweighed.
The construction industry has faced that right from the legalization of cannabis, is having employers who are swinging hammers and have saws and up on ladders, saying, "Oh, it's my right to." You're not your right during work hours to. So I mean, there are limitations. I mean, one of the other checks or questions that is related to health and safety, but along this, I think in the same vein is, people can get injured by not working properly. And meaning, do I sit in my dining room chair for 6 hours? Not a smart idea. Great for having dinner for a couple hours, but it's not good for sitting on Zoom. Or should I be sitting on this, ergonomic chair? In terms of the sort of the disability, it's almost the prevention of getting someone, is there some ability for employers to be saying, where are you working? I mean, here are the things that you should be considering, something with your feet on the floor, strong back, get up give a plan to try and make sure that you don't get to that disability stage. Is that still, that's what we would often do in the workplace, like at our workplace, we would put some of those things in place. So does that translate to a home-based environment?
Yeah, I think it does. I'm not sure that there's like a strict obligation, Ian, to do that, but it's certainly prudent to do that to avoid injury, right? And to avoid the sorts of problems that you're talking about, and sort of periodically, sending out a message, firm-wide email, all users email, sort of addressing those things, making people aware that and especially providing them an opportunity, right, to say, hey, I think I don't have that ergonomic chair. Is there anything that you can do for me, employer, to sort of avoid all these issues I have, that's certainly prudent, because, again, once it gets to the human rights issue, Ian, and the duty to accommodate, it's sort of a whole other can of worms, another conversation we're having, and it's much harder, I think, to navigate. So certainly trying to avoid those issues from the outset is advisable.
An ounce of prevention is with whatever the rest of that saying is, but it works there. Listen, I want to go on, Alicia. One of the things that is another one of these things that's come into more focus because of people working at home more during the last couple of years is electronic monitoring policy. I think we've always kind of said, hey, look, if you're using the internet or any email that is the workplace email, marginal expectation of privacy.
Yeah.
Certainly another extension of that is many employers provide not only the desktop and the email and the web and all those things, but they also provide one of these. Now, this is a BlackBerry that not many people would use. Again, I still hold on to mine because it's got a keypad to it, but I'm going to call this generically a cell phone. And so, those are provided by the employer. It allows you to work remotely, but it also is what people use for, there's virtually no, the connection between your working life and your private life gets really blurry when you use one of these, because it's where your family calls you, it's where your clients call you, etc.
Yeah.
Maybe let's talk a little bit about and this is related to, should you have a policy around that, whether you call it an electronic monitoring policy, or at least bringing clarity about what the employer can do, because I think it would probably shock employees.
Oh, I'm sure.
what can an employer, because we have reviews done by because we got an outside IT firm. We're going through periodically to say, are people doing stuff they shouldn't be doing, because they're told not to surf the web for things that they should rather be doing at home. So it's just that you're going to find out those things if you're doing any kind of monitoring.
For sure.
Talk about the policy part of that brings a sense of not fairness, but an understanding on both sides of what the rights and responsibilities are of the employer and what expectations employees can have.
Yeah, so it's actually just recently been legislated that any employer that has 25 or more employees has to have an electronic monitoring policy in place. That legislation was passed, became effective April the 11th. And the provisions are found in the Employment Standards Act. And businesses have until October the 11th to draft and implement the policy. So the policy itself requires that you set out whether you are electronically monitoring employees, and I'd be shocked if any business isn't. And even it doesn't even have to be the primary purpose of your use of a technology or software or device. If it, whatever purpose you might be, is possible for you to use that information from, it needs to be set out in the policy. So the legislation itself uses the word, the circumstances you may electronically monitor your employees, and the purposes for which you may do the monitoring. So you really need to be forward thinking. And for what's jumping out to me really would be the use of this information for disciplinary purposes or performance management purposes. A habitually late employee, when you think about, your key fob, I mean, that is a form of electronic monitoring, and pretty much every business has a key access card into where their, important information and their assets are. So you can easily monitor where your employees are coming and going just by looking at your key fob data. So chances are, if you have an employee who's habitually late, getting to work in the mornings, leaves a little bit early, late coming back for lunch, a source of data for you to rely on is your key fob data. So something like that would need to be set out in this electronic monitoring policy. So a lot of people may think that the policy is restricted to what we call Bossware. So kind of the surveillance software where it's, monitoring keystrokes, optical characters, things like that. But it's not. It's literally any type of electronic monitoring. When the government made the announcement, there was specific reference to monitoring an employee's use of computer, cell phone, GPS, or other electronic devices. And with everybody moving I shouldn't say everybody, but a lot of businesses moving to the hybrid model, or for a period of time having their staff work remotely, a lot of people were having to rely on a VPN for security purposes. And that the amount of data that your data protection software collects in terms of what's happening on the network is incredible. And, again, the primary purpose of having that in place is not employee monitoring. It is, just security. Yeah. But in case you use it, if you had a rogue employee who all of a sudden decides, I'm not happy here, or I'm offended by something the employer did, and introduce some kind of a threat into your network, you want to know, and chances are that's what you're going to rely on to get rid of that employee from your workforce.
Okay, and maybe you've raised the issue of Bossware. I don't exactly know what that is, other than it sounds like it's, being able to understand how much work is being done by an employee, and that's easy enough to do. I mean, even in our world, I know what people's jobs are, and I know if the job's getting done. So some of that could be verified by electronics if there was an issue. Others you're just going to know, but maybe talk about Bossware and what some examples would be, and if you're going to use it, what your responsibility is to make sure that there's this that employees know what you're monitoring.
Yeah, so Bossware is software that is specifically geared to tracking whether or not a person is working. A really common one is keystroke, monitoring keystroke. So if you stop typing for an extended period of time, and the employer or the person implementing the software can decide how that period of inaction, then they can get an alert that this person is not on their computer, and then the employer can take with that, do with the information what they wish. But likely it would be if it happens a few times, would be, hey, employee, why are you taking these extended breaks throughout the day? This is during work hours. You're supposed to be at your computer working. So that's what Bossware is. And there's various forms of it. Others are literally, if your eyes aren't looking at the screen for an extended period of time, then that is the alert. So it can be very intrusive, this software. So the privacy commissioner has said, not specific to Bossware, but in terms of any kind of electronic surveillance that you're conducting of employees, it cannot be covert. So you have to make sure that your employees are aware that you have this practice in place. They have indicated that you should also be informing your employees of what your policies are on the use of the internet, the use of email, appropriate use of the cell phones that you provide to them. P.S. I need to know how you managed to hold on to a BlackBerry, because I thought that they took it right off the system. So I'm impressed. But you should also ensure that if you're collecting information from an employee for one purpose, you aren't using it for something else. So definitely both the provincial and the federal privacy commissioners have really been stressing that there should be transparency between employers and employees when it comes to how their personal information is being collected and used.
Well, I consider it artwork now, actually. So it's a piece of art, and actually, this is my second black. This is my backup. I have a backup. This is an even older one, but it's my backup because it still has a keyboard. I'm slowly getting over that hang up that I have. So, but back to business here. Listen, George, I've heard a lot about this, and actually Greg DeRocher, my colleague from the Cambridge Chamber, we talked about this several times on Business to Business on our radio show when the right to disconnect legislation came out, and it made big headlines for only to discover that there was a lot less than meets the eye there. Was our observation, and it certainly is for, again, 25 employees or up. Maybe just kind of go over and give your assessment, because it is in place. It is in force in Ontario, but I think there's a lot less than meets the eye with this legislation. That's our observation, but I'm interested in whether we've misread that.
I think that's fair to say, Ian. I'm sort of always amazed to see on, I go on Twitter occasionally. I try not to, but I go on Twitter and, there's these, posts from various media outlets saying, you now have the right to, don't pick up the phone, when your employer calls you. And I just think, oh man, I don't know where that's coming from. I can understand that the present government wanted to make it seem as though that there was this right to disconnect, but you're precisely right. I mean, what's essentially there is that you have to have a disconnecting from work policy in place, right? And I believe it should be in place now. If you don't have one, you should probably get on it. But essentially, the way the legislation is drafted is that it says, in terms of the substance of the policy, refer to the regulations. Then you refer to the regulations, and there's nothing. So the regulations don't actually impose any actual substantive kind of rights for the employee. So it's still up to the employer to decide what they want included in that policy. And in fact, this was a big critique from employee advocates that, this is just sort of empty calories. There's not really much here, and it's not really doing too much. And I probably agree with that, but nonetheless, here's this extra hoop for the employer to go through, and you got to make sure that you have that policy. One thing I would say is that once you provide that right, though, right, it's like changing the terms of employment, right? So if this is something that, in order to attract talent, that you want to have a generous disconnecting from work policy, and very specific rules vis-a-vis that policy, and what the employee has to do when they have to do it, whether they have to respond to that 11:30 p.m. email with the exclamation point on it. You can choose to do that if you like, and if you think in the long run it's going to be good for your business, that's great. The only thing I would say is, once you make it that right, once you implement it as an employer, then it does become a sort of contractual right, because the terms of employment have changed at that point, and you're granting the employee certain rights under the policy.
I think the difference is for the smaller business under 25, they really are exempted from it. But
That's
I
right.
think the idea is that you would want to, as a good employer, to use the principles there and of trying to lay this out. I'm notorious. I'm a night owl. I send out emails. Oh, I woke up at 1 o'clock. Geez, I forgot to email something. And I constantly get, geez, I got your email at 1 a.m. And I've had to, for my staff, say, I know your hours are 8:30 to 4:30. Anything outside of that, I don't expect you to get back to me. I'm doing it to get off my desk. And I know there are other tools. I'm just not very good with technology. But the important part is even for a smaller than 25 employee firm, probably wise to make sure it's clear what people's work hours and what the expectation is of management. And I think that's because the legislation's there, but again, it's size of business. And then, as you say, even for those larger employers, until you fill in your own regulations, it's really,
right.
it's an empty, it's a no calorie Big Mac, and there is no such thing. So, okay, listen, we got about 2 minutes to go. So these are going to have to be quick round here. And I'm going to start with you, Alicia. Data breaches are hugely disruptive. They can be expensive. They can be, they can actually buckle your knees in terms of business. What should small businesses be looking at to try to prevent a data breach in the first place?
For sure. I'd say the first thing is make sure you know what your obligations are and comply with them, because the government has in place legislation that if you're following will help prevent data breaches. I think honestly, the most important thing, develop policies and procedures to protect your client's personal information, your business's proprietary information, and then train your employees on those policies and procedures. Most breaches happen accidentally because somebody clicks on the wrong link in a phishing email, and now the threat has been introduced into your network and it's shut down, and your business is effectively crippled when you cannot access the data that you need to operate. So definitely make sure that you're training your staff and your employees on what they should be doing to protect the network, protect the data. Make sure that you do have appropriate security safeguards in place, and that would include things like physical measures. So keeping, not having important, like if you're leaving your workstation, lock it so that somebody can't just come up and do things to your workstation. Technological tools, so there's software programs for data protection. Also, before you onboard new technology, make sure that you're doing a risk assessment. Like, this new technology have appropriate protections in place to protect your data, or are you just providing a backdoor to nefarious characters to come in and hurt your network? Another thing too is, if you are thinking about acquiring, taking over another business, purchasing a business that you're going to bring into yours, make sure that you're evaluating what their data protection practices are. It might seem like a great investment for your company, but if you do your due diligence and start digging, and you're like, oh my gosh, their network is horrible. There's so many open doors. You'd need to evaluate what your purchase price is going to be, and what steps you're going to need to rectify those issues if you do decide to move forward with that transaction.
Okay. Last question, George, and then we're completely out of time. So you got 45 seconds for this one.
All right.
Severance, how is it typically calculated? Like notice or severance? I think some of the question is, has it changed during COVID? And if not, give people a refresher of what that looks like if they are letting someone go.
If you are letting someone go, the first thing I would say is the Employment Standards Act is just the minimum entitlement. So you need to, and this goes back to our initial conversation, Ian, you need to consult your employment contract and see what it says there. And just don't assume that provision, which was signed 10 years ago, maybe, is still enforceable. Have a lawyer take a look at it and give you an opinion as to whether or not it's going to withstand judicial scrutiny. In terms of how much an employee is entitled to, the presumption is common law reasonable notice. And that's just based, essentially on tenure, right? There are other factors that are present, but tenure is probably the most important one. The next one is probably age. The idea is the longer you've been employed, the older you are, the more that the court is going to presume it's going to be difficult for you to find a new job. That gets calculated. There's a rule of thumb. It's just a rule of thumb. I'll mention it here. It doesn't mean it applies to you, but the idea is about 1 month per year of service, okay? And it goes up to maximum, under normal circumstances, about 24 months, right? Again, this is another important reason why you want to have an employment contract that sort of limits an employee's entitlements upon termination.
Listen, for us old guys, that's important information to have, because we don't want them to just take us behind the barn and, I'll leave that analogy there. But thank you for that's good. It is important for employers to understand that length of service and age and all those things will come into play. And I think for sure, minimums in the Employment Standards Act, don't take those to the bank. Listen, you guys have been awesome. Thanks so much for joining us today. You both have done an excellent job. I threw you a few curveballs, but you did a great job. So George and Alicia, thanks so much for joining us today. And thanks again to our title sponsor for the series, Manulife, our platinum sponsor for the series, the Immigration Partnership of Waterloo Region, and to June's sponsor, Learners. And finally, to all of you for joining us today. Join us next week for the final session in the Business Success Series, Why Waterloo Region Needs the Youth Creativity Fund. We'll be joined by Scott Higgins and Scott Verhove, who will join us about an innovative youth creativity fund being established thanks to a $100,000 donation by HIP Developments. Waterloo Region youth in grades 5 to 12 can look forward to micro grants of up to $1,000, enabling them to apply their creativity towards solving problems. Now, a community that has benefited from its creative legacy is challenged to give back, because by supporting the creative growth of our youth, we contribute to our future success. To register, to find more about other upcoming events, please visit us at greaterkwchamber.com. Thank you for joining us for today's Business Success Series. Because if it's Wednesday, it is the Business Success Series. Thanks so much for joining us.